Welcome back to Holocaust, Genocide, and International Law. This is Class 7, Defining Recent Atrocities. Breakdown of today's class. In Part 1, we're going to look at the term ethnic cleansing, a term bandied about in the press quite often, but whose definition is more murky and complex when considering how it translates into actual crimes in international law. As the readings this week show, actions composing ethnic cleansing may fall within three different major international crimes: genocide, crimes against humanity, and war crimes. Since genocide has been, up until now, the focus of our studies in this course, this week we will augment our understanding of genocide, looking at the separate but related crimes of crimes against humanity and war crimes in an effort to be able to distinguish each of them as they may apply to modern atrocities. We'll use the example of the situation in Myanmar with the Rohingya. With that being said, in Part 2, we're going to look at the crime of crimes against humanity and how its definition has evolved from the time of Nuremberg until the present. As we've discussed in previous lectures and course readings, instead of expanding the definition of genocide, the solution of the international community has been to expand the definition of crimes against humanity to gap fill areas previously not covered by either the criminal definition of genocide or the older definition of crimes against humanity. In Part 3, we'll look ever so briefly at the crime of war crimes. International humanitarian law and the law of armed conflict is a course unto itself, but it bears mentioning here because when crimes are committed as part of an international armed conflict, so an armed conflict that crosses international borders, or a non-international armed conflict, an armed conflict that does not cross international borders, there are treaties and rules of conduct, the violation of which opens the perpetrator up to international criminal liability. As your readings this week noted, war crimes might also be at play in the situation with the Rohingya in Myanmar. And finally, in Part 4, we'll look at the situation of the Rohingya in Myanmar. We'll look briefly at the facts, the international actions to date, the possible international crimes that have been committed, but we will leave the deep discussion on the Rohingya for forum discussions. Finally, we'll conclude with a conversation with Professor Rajika Shah, who is the author of one of your readings this week, and who is also the Deputy Director of a Law and Genocide Clinic. We'll get her perspective on the Rohingya, as well as her practical insights into what a clinic on law and genocide in the 21st century does in order to contribute to achieving a measure of justice in connection with any number of historic, recent, or current atrocity situations. Let's get started. Recap of Class 6, Holocaust as a Catalyst for Modern International Criminal Justice. Last week, we examined how we got from Nuremberg to The Hague and how we now have a substantive set of laws for international criminal justice, and specifically for the crime of genocide and a permanent place for the trial of genocide and related crimes. The principles of Nuremberg were established in the mid-1940s, but it took until the thawing of the Cold War for the international community to reconvene to discuss a basis, a treaty, and a location, The Hague, for international criminal prosecutions. The rise of inter-ethnic conflicts in the Balkans and Rwanda caused the Security Council to set up two ad hoc tribunals in the 1990s for the international criminal prosecutions of the most serious offenders in those two conflicts, and the ad hoc tribunals' relative successes gave momentum to the establishment of this permanent treaty-based court, the ICC, the International Criminal Court. We look specifically at the ad hoc tribunals, what Michael Basler in Holocaust, Genocide, and the Law described as Nuremberg's progenies, and how they were not just progenies, but they were created to be a better Nuremberg. And we looked at a number of factors associated with the tribunals becoming a better Nuremberg. And we noted that our understanding of the international crime of genocide comes from the judgments of these tribunals, also including the relatively new judge-created doctrine of joint criminal enterprise, as well as our heightened understanding of direct and public incitement to commit genocide, and also command responsibility. We concluded our dive into the ad hoc tribunals by looking at some of the criticisms of those courts. And then we ended our lecture last week by looking at the treaty-based ICC, the first permanent treaty-based international criminal tribunal with jurisdiction over the crimes of genocide, war crimes, crimes against humanity, and aggression. But we did note that the crime of genocide has not yet been tried at the ICC. And then finally, we noted that in the Genocide Convention, Article 6 provides for prosecution of perpetrators not just in an international forum, but also before courts with territorial jurisdiction, so domestic courts. And we looked at a few examples of domestic prosecutions of genocide. And with that, that concludes the recap of Class 6. Part 1, what is ethnic cleansing? In our reading, Lieberman said ethnic cleansing is related to genocide, but ethnic cleansing is focused more closely than genocide on geography and on forced removal of ethnic or related groups from particular areas. The UN has also stated that the term ethnic cleansing is relatively new. Considered in the context of the conflicts in the former Yugoslavia, ethnic cleansing means rendering an area ethnically homogeneous by using force or intimidation to remove persons of given groups from the area. But the UN has also said that the abhorrent policy of ethnic cleansing, which is a form of genocide. But most countries still use the term in a way that indicates that ethnic cleansing is related but distinct from genocide. Ethnic cleansing as a term was never considered during the drafting of the Genocide Convention, but the idea that rendering an area ethnically homogeneous by using force or intimidation to remove persons of given groups from the area, according at least to William Chavis, has a long history with international relations, but it was only in the 20th century that it was understood to be a human rights violation. For example, if you think of post-war Europe, the Allies forcibly removed ethnic German populations from Western Poland. And when the Genocide Convention was drafted, the United States was concerned that the proposed definition of genocide might be extended to embrace forced transfers of minority groups, such as those that had already been carried out by the UN. Looking still at what is ethnic cleansing, the ICJ, the International Court of Justice, in the case of Bosnia v. Serbia, had to say the following about ethnic cleansing. Neither the intent as a matter of policy to render an area ethnically homogeneous, nor the operations that may be carried out to implement such policy can as such be designated as genocide. The intent that characterizes genocide is to destroy in whole or in part a particular group, and deportation or displacement of members of a group, even if effected by force, is not necessarily equivalent to destruction of that group, nor is such destruction an automatic consequence of the displacement. So the intent and purpose of ethnic cleansing is forced displacement rather than physical destruction. And William Chavis has an interesting historical example that's apropos to this course that I'd like to share with you in his book on genocide and international law. He said, as an historical example, until 1941, Nazi anti-Semitic policies were directed towards convincing Jews in Germany to leave the country. Jews were required, of course, to pay a price for their freedom, and large numbers who attempted to leave were unable to find refuge because other civilized states refused to admit them. The Nazi policy at the time was one of ethnic cleansing. Jews were incited to leave by various forms of persecution, including discriminatory laws and periodic outbursts of violence, such as what happened with Kristallnacht. And after the war against the Soviet Union was underway, the Nazi policy became destruction of Jews of Europe, in whole or in part. No longer was emigration permitted, even if asylum was possible. At this point, the Nazi policy became genocidal. The District Court of Jerusalem in the Eichmann case noted this evolution in Nazi policy, commenting that, quote, the implementation of the final solution in the sense of total extermination is to a certain extent connected with the cessation of emigration of Jews from territories under German influence, close quote. Until mid-1941, when the final solution emerged, the Israeli court in Eichmann said that, quote, a doubt remains in our minds whether there was here that specific intention to exterminate, as required by the definition of genocide. The court said it would deal with such inhuman acts as being crimes against humanity rather than genocide. And so Eichmann was acquitted of genocide for acts that were committed prior to August 1941. Schabas concludes in this example by saying, in a sense, both genocide and ethnic cleansing may share the same goal, which is to eliminate the persecuted group of a given area, even though ethnic cleansing tolerates the existence of the group elsewhere, whereas genocide may not. Hitler had the modest ambition of eliminating all Jews in Europe, but given the chance, he would have extended his murderous campaign to the rest of the world. Milosevic, for example, on the other hand, wanted to drive Muslims from Kosovo, although he seemed untroubled by the idea that they might live elsewhere in Macedonia or Albania. Is there a meaningful difference? While the material acts performed to commit the crimes may often resemble each other, they have two quite different specific intents. One is the intent to displace a population, the other to destroy it. The issue of one is one of intent, and it is logically inconceivable that the two agendas coexist. Of course, as the Eichmann judgment notes, ethnic cleansing, which was described as deportation, remains punishable as a crime against humanity and a war crime. And in William Schabas's example, you can kind of see that ethnic cleansing may be a warning sign of genocide to come. That was the case in the Holocaust. That was also the case in the Yugoslav Tribunal, where the ICTY found that Krstić had a plan to ethnically cleanse the Srebrenica enclave of Muslims, but that escalated into a genocide plan designated to guarantee that the Bosnian Muslim population would be eradicated. So it's possible that the antecedent of the Holocaust could be described as ethnic cleansing, as well as what happened during the conflicts in the Balkans in the 1990s. In what other contexts have we heard the term ethnic cleansing used most recently? One would be the situation with the Rohingya in Myanmar, which we'll look at a little bit more later in this lecture. And another one that came to my mind was perhaps what's going on with the Uyghurs in Xinjiang province in Western China, where, as many of you are probably aware, up to a million Muslim Uyghurs have been placed into extra legal concentration camps by the Chinese government in the province. And the government is calling these camps a sort of vocational or employment training situation. But inside the camps, the Uyghurs are being pressured to renounce their religion through actions that have allegedly amounted to cruel, inhuman, or degrading treatment, or even torture. And another 1 to 2 million Uyghurs who are not in detention have been forced to undergo indoctrination sessions and are also subject to a technological net that the government has sort of put over the region to monitor those individuals who haven't been put into detention camps. Can you think of other situations that have been labeled ethnic cleansing recently? Is there an international crime for ethnic cleansing? The short answer is no. There is no convention for ethnic cleansing. So when we hear the term ethnic cleansing and that ethnic cleansing is occurring, what does it mean when described in terms of legally recognized international crimes? Well, the UN Commission of Experts has described practices employed in ethnic cleansing as crimes against humanity that can be assimilated to specific war crimes, and such acts could also fall within the meaning of the Genocide Convention. Well, we're intimately familiar with the crime of genocide, so let's have a look at crimes against humanity, particularly how it has evolved as an international crime during the 20th century into its current ICC definition, to assess how ethnic cleansing could be prosecuted in international law as a crime against humanity. Part 2, defining crimes against humanity. Some call the crime of crimes against humanity a sort of backup crime to the crime of genocide, but recall from the ICTY statute's preamble that Genocide, war crimes, and crimes against humanity are all serious violations of international humanitarian law. And recall in class 2 that you read Jabus's chapter from the Oxford Handbook on Genocide Studies, and where he noted that instead of expanding the definition of genocide in the 1990s, it was the, quote, atrophied concept of crimes against humanity that emerged as the best legal tool to address atrocities. The international community opted for an expanded view of crimes against humanity. So, what does crimes against humanity cover, and what does it require? Generally, it requires a certain type of act, such as murder or deportation, committed as part of a widespread or systematic attack against civilians in peace or in armed conflict, with the necessary mental elements of intent and knowledge and any special element that applies to the core crime. So how does crimes against humanity differ from other international crimes? Really, it's points 2, 3, and 4 that we just looked at. It's the widespread or systematic attack against civilians in peace or in armed conflict. And specifically with crimes against humanity, there is no need to show the dolus specialis or the specific intent to destroy a group in whole or in part, as is the case with the crime of genocide. Now, what's the scale of the atrocity that must have occurred in order for it to raise the level of crimes against humanity? Well, it could be just a single individual. As the appeals chamber in the ICTY case of Prosecutor versus Kreisnick said, quote, except for extermination, it is not necessary that a crime be carried out against a multiplicity of victims to constitute a crime against humanity. An act directed against a limited number of victims or even against a single victim can constitute a crime against humanity, provided it forms part of a widespread or systematic attack directed against a civilian population, right? So you need to be able to hook even just a single attack on an individual. If you can hook it back to a larger widespread or systematic attack, then it could be part of a crime against humanity. Evolution of the concept of crimes against humanity in customary international law. While crimes against humanity is a crime in international law, like ethnic cleansing, it doesn't have a convention definition. There are no conventional roots, unlike the crime of genocide. There is work being done by the International Law Commission, right? We discussed in class 1, this is a group of international experts that looks at codifying, so reducing to law, customary international law. So they're working on draft articles on the prevention and punishment of crimes against humanity, and also a definition of crimes against humanity, but that's still in the drafting stage. There is no convention for states to sign on to. The customary rule is what has formed the basis of jurisdiction for crimes against humanity at the ICTY, the ICTR, and the ICC. But each of these tribunals have had different definitions of the crimes against humanity, and none of them are identical to the definition at Nuremberg. So there's been this sort of evolution and tailoring of the notion of crimes against humanity from customary international law to fit particular atrocity situations. So let's have a look at some of this evolution of crimes against humanity. That customary international law prohibits crimes against humanity is rooted in the notion that there's really something inherently wrong with going around and butchering people, if you will. But also keep in mind, as we look through the legal evolution, that it is a lot easier to make declarations when you're the victor of a given situation and you're talking about the losers acting inhumanely. So if we go back to 1915, the Joint Declaration on the Armenians, France, Great Britain, and Russia condemned the Ottoman government's massacre of the Armenian population of Turkey as constituting crimes of Turkey against humanity and civilization. And then the Treaty of Versailles in 1919, as I'm sure many of you are aware, Article 227 stated that Kaiser Wilhelm II was to be placed on trial for a supreme offense against the international morality and sanctity of treaties. This never materialized because in part because U.S. delegates were opposed to the establishment of an international tribunal to try war criminals. But They recognize that a wanton act which causes needless suffering, and this includes such causes of suffering as destruction of property, is cruel and criminal. The full measure of guilt attaches to a party who without adequate reason perpetrates a needless act of cruelty. Such act is a crime against civilization, which is without palliation. Following the legal evolution next through the IMT Charter, Control Council Law Number 10, and the Nazi and Nazi Collaborators Act of 1950. In the IMT Charter, Article 6C, which we've gone through many times and I'm not going to read again, we see the core definition of crimes against humanity that we still use today, the notion of crimes against any civilian population, not just combatants in an armed conflict. This now includes crimes against civilians. And it doesn't matter if the act was lawful under domestic law, but for the IMT Charter, the actions had to have a war nexus. They had to be connected to war. As Professor Shaw notes in one of your readings from this week, one of the major contributions to contributions to international law from the IMT definition was that it permitted prosecution of acts that occurred against a state's own nationals. Because recall, when we looked at sources of international law, traditionally what a state does inside its own borders really wasn't of international concern. Looking next at Control Council Law Number 10 and the definition. The definition has now expanded the crimes to include, for example, torture and rape, and also persecutions on political, racial, or religious grounds. And there is no war nexus in the definition from Control Council 10. Looking finally at the Nazi and Nazi Collaborators Act, similar to the Control Council Law Number 10, it augments the IMT Charter definition of crimes against humanity by adding persecution on national, racial, religious, or political grounds. So slowly we're getting a more robust, more comprehensive definition of crimes against humanity. Jumping ahead a couple of generations and looking at now the ICTY statute, Article 5 describes the crime of crimes against humanity. What are the similarities and differences between the ICTY definition and the three definitions from World War II that we looked at? Well, you'll see in italics, there is the phrase committed in armed conflict. So the ICTY has added back in that armed conflict nexus that was present in the IMT definition of crimes against humanity. So is armed conflict actually part of the crime of crimes against humanity? Recall, yes, the nexus was required at the IMT with respect to the Control Council Law Number 10 and the Nazi and Nazi Collaborators Law. It was not required. The ICTY has it. The ICTR does not, nor does the ICC statute. So the tribunal, the ICTY, in the case of Prosecutor versus Tadich, said that it is, quote, now a settled rule of customary international law that crimes against humanity does not require a connection to international armed conflict. It was just the case that even though international law doesn't require this armed conflict nexus, because of the nature of the situation of what happened in the conflicts of the Balkans, it happened to just be a jurisdictional prerequisite for that particular court, meaning that it was a requirement of the ICTY that there be this armed conflict nexus, but it does not reflect customary international law that there has to be an armed conflict nexus for there to be a crime against humanity. Looking next at the ICTR statute, Article 3, and compare how its definition of crimes against humanity is different or similar to that of the ICTY. If you look at the chapeau of the definition, that is the top part of the definition before you get to the enumerated crimes of A through I, which tells you how the crime must be committed. Notice that for the ICTR, the crime has to be committed as part of a widespread or systematic attack against any civilian population on national, political, ethnic, racial, or religious grounds. So in the chapeau, there must be the attack based upon national, political, ethnic, racial, or religious grounds. But then also one of the enumerated crimes is persecution on political, racial, or religious grounds, which makes the crime of persecution very high. Because at the ICTR, you have to have a double showing targeting the group in the broad context, right, in the chapeau, and then you have to show the persecution specifically occurred as one of the enumerated crimes. And as we mentioned previously, for the ICTR, there is no requirement of an armed conflict nexus for a crime against humanity to be found. And finally, looking at the definition of crimes against humanity most recently in the ICC statute. If you just look at it on the screen, you should be able to visually see that it is much more robust and longer than all of the definitions that we looked at previously. And I urge you to sort of look at the definition as an extreme compromise in trying to get all states to adopt the Rome Statute. If you look at the enumerated crimes that are included in the crime against humanity, they now include things such as forcible transfer, imprisonment, a more robust definition of rape as a crime, persecution against any identifiable group or collectivity, enforced disappearances, and apartheid. So in looking at these definitions, you might be able to understand why there was a fear by some states of sort of so-called Europeanization, or ending up with a definition that is so elastic as to cover all kinds of human rights abuses as those Western states would define by their standards, but perhaps not by the standards of others. So then looking back up at the chapeau, right, how the crimes must be carried out. And that's really important when we're looking at crimes against humanity. So if we break it down into a few component parts. So for the purposes of the statute, crimes against humanity means any of the following acts when committed as part. This is the nexus requirement. This links the regular crime, for example, murder, to a widespread or systematic attack, which then makes it crimes against humanity. The accused has to know that his acts are part of something bigger. He doesn't need to know that there's a master plan, but he needs to know that what he's doing is happening on a larger scale than what's happening in the present. And then looking at the term widespread or systematic attack. Attack doesn't mean a military attack with heavy artillery, but it could be. It really means launching harmful conduct against an identified civilian population. And the term widespread, cases tend to look at the scale or numbers or having a multiplicity of victims. For example, in the ICTR case of Prosecutor versus HGAIL, the court found that it was for widespread, massive, frequent, large-scale action carried out collectively with considerable seriousness and directed against a multiplicity of victims. Then systematic. Systematic is organized, planned. You have to look for a pattern, show that it's not random. Now, does it need to be part of a formal state or political policy? No, but that can be used as a factor to prove systematic. And note that the definition says widespread or systematic. Again, this reflects another compromise, because if it had to be widespread and systematic, it would be much harder to prove that a crime against humanity had occurred. Now, looking then at the phrase directed against any civilian population. This is not the same necessarily as a military objective. Directed against means that it's not random. That means that the population has been pre-selected and that they are civilians. Any means that's open, that's random, that's not particular people, such as, for example, blondes or brunettes. Civilian population. This comes from the law of international armed conflict, which distinguishes individual civilians from combatants. And then with knowledge of the attack is the last part. So there's a mental component, and each of these parts of the chapeau must be proven beyond a reasonable doubt, right? That's the criminal standard of proof. And proving the chapeau, the top part, the widespread or systematic attack directed against any civilian population with knowledge of the attack, is what makes the core crimes A through J crimes against humanity, and not just, for example, murder or rape or prostitution. Part 3, defining war crimes. We've looked extensively at how to define genocide in international law, and recently how the evolution of the crime of crimes against humanity has sort of coalesced into a rather robust definition in international law under the ICC statute. But what about the third crime that we want to look at today, war crimes? What are war crimes? Professor Shaw, in her article Assessing the Atrocities, describes war crimes as any act or omission committed in an armed conflict that constitutes a serious violation of the laws and customs of international humanitarian law and has been criminalized by international treaty or customary law. And for war crimes, liability to attach to an individual perpetrator, the act or omission must violate the primary rules governing the conduct of war, as well as the secondary rules concerning the punishment of war crimes. What do war crimes encompass? They include grave breaches of the 4 Geneva Conventions, some of the grave breaches from Additional Protocol 1 to the Geneva Conventions, serious violations of customary international law governing armed conflict, including Common Article 3. This is Common Article 3 from the Geneva Conventions, which is arguably the most important article. And even though it says that it only applies to non-international armed conflict, it's also important. It's so important that it applies basically to any armed conflict, non-international and international, and its customary international law. That's the most important article. And war crimes also encompass violations of other general principles and rules of the protection of victims of internal armed conflict, and breaches of certain fundamental principles and rules regarding means and methods of combat and civil strife. And that gives you the overview of what war crimes encompass for our purposes today. That's more reference information than something that you really need to digest and internalize. Unlike crimes against humanity, whose modern definition under the ICC does not require an armed conflict nexus, for there to be a war crime, the act must be closely related to the armed conflict, whether the armed conflict is international, crossing borders, or internal, very domestic in character. The ICTY Appeals Chamber, in the case of Prosecutor versus Kuneratz, said that what ultimately distinguishes a war crime from a purely domestic offense is that a war crime is shaped by or dependent upon the environment, the armed conflict in which it is committed, right? Because otherwise, again, it would be the crime of murder without the nexus. The nexus makes it a heightened international crime. And also just a point to note here, when the media sometimes talks about the ICC or the ad hoc tribunals as sort of quote unquote war crimes tribunals, it's a bit of a misnomer, right? Because not all crimes are war crimes. War crimes, you need the armed conflict nexus, but you can have crimes against humanity or genocide, as we've discussed, without that armed conflict nexus. Taking the ICTY statute one more time as our example, let's look at how the statute describes war crimes in Articles 2 and Article 3. Article 2 addresses grave breaches of the Geneva Conventions of 1949. So it gives the ICTY jurisdiction over the following acts against persons or property protected under the provisions of the relevant Geneva Convention, which includes, so war crimes can include willful killing, torture or inhuman treatment, willfully causing great suffering or serious bodily injury, extensive destruction and appropriation of property, compelling a prisoner of war or a civilian to serve the forces of a hostile power, willfully depriving a prisoner of war or a civilian of the rights of fair and regular trial, unlawful deportation or transfer or unlawful confinement of a civilian, and taking of civilians as hostages. So that's Article 2, grave breaches of the Geneva Conventions. Looking then next at Article 3 of the ICTY statute, it describes violations of the laws or customs of war, and this gives the tribunal jurisdiction to prosecute persons violating the laws or customs of war, which include, but the ICTY statute says, but are not limited to, for example, employment of poisonous weapons or other weapons calculated to cause unnecessary suffering, wanton destruction of cities, towns, or villages, or devastation not justified by military necessity, attack, bombardment, by whatever means of undefended towns, villages, dwellings, or buildings, seizure of, destruction, or willful damage done to institutions dedicated to religion, charity, and education, the arts and sciences, historic monuments, and works of art and science, and plunder of public or private property. So, sort of bottom line from this very cursory and sort of 30,000 foot inquiry with the armed conflict nexus, the enumerated or lettered actions that we've described in the ICTY example amount to actionable war crimes. The ICTR and the ICC have related, but again, slightly different language in their respective statutes or rules, if you will, for what amounts to a war crime in those particular tribunals. But again, there is no specific intent requirement as there is with genocide, but there is, unlike crimes against humanity, an armed conflict nexus requirement. In part 4, let's put together everything we've discussed previously in defining recent atrocity crimes, ethnic cleansing, which is often used in the press to describe atrocity situations, is not an international crime, but it does encompass the other international crimes of genocide, crimes against humanity, and war crimes, each with their own specific and nuanced definitions. Genocide having the dolus specialis, war crimes having the armed conflict nexus, and the most recent modern definition of crimes against humanity having neither of those requirements, but it must be committed as part of a widespread or systematic attack on a civilian population. So looking at those three crimes in connection with the example from this week's readings, the Rohingya in Myanmar, let's look briefly at the situation. This is basically what the UN has termed as a human rights catastrophe experienced by the Rohingya as a result of the Myanmar state military's clearance operations. The military, of course, says the violence was caused by Rohingya terrorists, but human rights groups, news outlets, and the UN have all found evidence of a decisive and deliberate purge of the ethnic minority Rohingya after decades of intensifying atrocities that amounts to genocide. And to put this in round numbers, around 800,000 fled in 2017, along with another 200,000 who had fled previously from the region. Most of these Rohingya who have fled their homes are now living in refugee camps in neighboring Bangladesh or in internment camps in Myanmar. And domestic laws have stripped the Rohingya of their citizenship, making them effectively stateless. The international community has taken a few major actions to date. The first in time from earlier this year was that the ICC prosecutor has sought a ruling from the court on its territorial jurisdiction after finding evidence of sufficient evidence of deportation. And if that sounds like a bunch of legal mumbo jumbo, that's basically a really legal way of saying the court's trying to figure out if it can look at the situation because, and we'll go into this a little bit more in my conversation with Professor Rajika Shah at the end of the lecture, Myanmar is not a member of the Rome Statute, which makes it difficult for the ICC, absent Security Council intervention, to look at what was going on there. Another international action to date was the issuance of the report of the Independent International Fact-Finding Mission in Myanmar. The summary was published in August. That was part of your reading. The full report, which is more than 400 pages, was published in September, and it goes over extensive factual findings. It applies the facts to the crimes that we've discussed today, genocide, crimes against humanity, and war crimes. And then at the end, it also issues a couple dozen recommendations of what the international community should do going forward. Finally, to drill down one more time, while the media has called the situation with the Rohingya in Myanmar, as well as many other situations that have unfolded worldwide, ethnic cleansing, there is no internationally defined crime for ethnic cleansing. So we must look to other crimes in international law to cover the horrific situation befalling the Rohingya, and in this situation, it includes crimes against humanity, genocide, and war crimes. The article written by Professor Shaw that was assigned as part of your reading this week was written before, just slightly before, the UN report came out in August. Have a think as you read through it. Do her conclusions on possible international crimes match the findings from the UN fact-finding report? What facts did the UN report document that served to bolster Professor Shaw's position that genocide, crimes against humanity, and war crimes may have occurred? Keep those questions in mind as you work your way through some of the discussion questions this week. We're going to conclude this week with a conversation with Professor Shaw. She was kind enough to share some of her background and thoughts relating specifically to her piece on the Rohingya and their situation in general, but she also offers us some practical insights as to what a clinic on law and genocide in the 21st century does in order to contribute to achieving a measure of justice in connection with any number of historic, recent, or current atrocity situations.